It's also not a case about whether or not our Constitution guarantees every child in the state an opportunity to obtain a sound basic education. That right was granted in Leandro. Instead, the case is about whether the trial court, when presented with only district-specific claims, had jurisdiction to issue a sweeping statewide order, or statewide orders, that required the comprehensive remedial plan, a plan which dictates virtually every aspect of education policy and funding, not just for the districts that were plaintiffs, but for all 115 school districts across the state, effectively removing those decisions from the political and the democratic process. Judge Ammon's order below, recalculating the amounts that were obligated to be paid in order to fund the CRP, is only the latest in a series of decisions that required the state to implement and impose the CRP. As we've argued, the trial court had no jurisdiction to issue those orders, and thus all of those orders should be overturned for four principal reasons. The first reason was not addressed in Hope County 3, the court's decision in November 2022. It is because the plaintiff's claims relate and turn on the conditions in their individual school districts, they do not have standing to assert claims regarding or to obtain remedies that dictate the outcome or that dictate policies that need to be imposed in districts where they do not live. The other three grounds and reasons that the court lacked jurisdiction were addressed in Hope County 3, but we believe that this court should reverse Hope County 3 as to those reasons. Yes, sir.
I have a basic question for you. Do we have any students left in this case? Are any of the named plaintiffs actually public school students?
Just by the sheer age of the case, Your Honor, and when the last plaintiffs were added, I would say no. There's been no discovery for quite some time, so I don't know that for a fact.
Is that significant?
I think that it may be significant when the case is remanded, Your Honor. I think that there may have to be a decision whether those plaintiffs who have moved on from school now by likely 15, 20 years are plaintiffs who could actually represent those who attend schools now, and even in their home districts.
Have there been any interveners? Have there been any intervening students since the Penn interveners?
Not to my knowledge, Your Honor.
Mr. Tilley, you assert repeatedly in your briefing that there's been no finding of statewide violation. I want to ask you about a couple of findings and excerpts from Judge Manning's four-part memorandum order in 2000. So are you familiar with, in Section 4, when Judge Manning said, reduced to essentials, the plaintiffs and plaintiff interveners have produced clear and convincing evidence that there are at-risk children in Hope County and throughout North Carolina who are, by virtue of the ABC's accountability system and other measures, not obtaining a sound basic education?
Yes, ma'am, I am.
And you standing here today say that's not a finding of a statewide violation?
This court amended and modified Judge Manning's four-part decision that came out of the trial in Hope County. And it said specifically that because the case was and the trial was premised only on evidence as it pertains to Hope County, our holding mandates cannot be construed to extend to the other four districts.
Well, then let me ask you about a different part from Section 1, where Judge Manning said the parties introduced a total of 670 documentary exhibits consisting of many thousands of pages relating to the operations of the North Carolina public school system in general and the Hope County public schools.
Yes, ma'am. One of the principal claims of the plaintiffs and one of the principal ways in which the court assessed the educational opportunities being offered in Hope County was by comparison to other districts. So it was necessary to not only explain how the state system works, the funding and allocation system, but also to explain how Hope County's inputs and outputs, to use the language of the Hope County 1 decision, compared to the rest of the state. And so the mere fact that the court, or that Judge Manning received statewide evidence does not mean that his judgment properly extended beyond Hope County. And in any event, this court in Hope County 1 recognized that he received that evidence. In fact, it recited that he received that evidence, and then specifically said, But our holding mandates relate only to Hope County, and we remand for further. We realize that the other four rural plaintiff school districts haven't been dismissed from the case. We remand for proceedings on their claims. There would have been no need to remand for proceedings on their claims had Judge Manning's decision been sufficient to find a violation for them as well.
Counsel, I had a question. So when we took this case, there was a concurrence that I joined that asked some questions, and we asked those questions because I find it to be the most important questions I'm trying to understand about Leandro 4 and what it means. And I was a little frustrated when I read there's so many briefs from so many parties in this case, and I really could not find in any of the briefs just an answer to my simple question. So I want to ask you, I want to ask your friends for the appellees as well, but
Yes, sir.
Suppose that we affirm trial court order in this case, and the comprehensive remedial plan begins to take effect, money's being distributed, we're 1 or 2 years in, and in some school districts somewhere in our state, up in the mountains or down on the coast, there's a group of students who've never heard of Leandro, who have no idea this case exists or anything about it, but they're not getting a sound basic education in their school. They get together with their parents, they get a lawyer, they get experts to explain what needs to be done to fix their school so they can get a sound basic education, and they go to court and they file a lawsuit. What's going to happen to that lawsuit? I just want to know, will those parents be told by a trial judge, sorry, your rights have already been decided? Or can there continue to be many, many more Leandro suits anytime a group of students think something needs to change in their schools to get a sound basic education?
And Your Honor, one of the reasons we may have not have addressed that as directly as we probably should have is that I realize that that's the mirror of standing, right? So if plaintiffs can't represent or obtain remedies for others who aren't represented in the case, it would stand to reason also that other parties can't be bound by the case. That's typically the only way to bind non-present, parties who aren't present is through a class action, which has all sorts of other showings, commonality, predominance, also that there would be certain due process protections to make sure that others' rights weren't foreclosed. So I think you're exactly right, and I think one of the other those plaintiffs in another district would be able to bring a lawsuit. They certainly wouldn't, as a matter of res judicata, be precluded or claim preclusion be precluded, and we'd have either conflicting orders or something that needs to be resolved.
The thing I'm struggling with is you said I'm right, but it was a question. I don't have the answer. There must be an answer based on Leandro 4. Is it that the comprehensive remedial plan is comprehensive? It's binding every student in the state. Their rights that have been violated by the state are being remedied by this order, or not. It's some small pocket of relief, and there will be many more Leandro suits. And there must be an answer, but I can't find it in Leandro 4, and the parties don't seem to be able to give me an answer.
I think the reason it's difficult to give you an answer is because the court shouldn't have jurisdiction to bind those plaintiffs in those other districts, Your Honor. And so, to say that the court does would assume somehow that the court had jurisdiction to take a Hope County specific claim that was based on the conditions in Hope County and then issue a remedy that bound all 114 other school districts and bound children in Asheville City Schools or Charlotte-Mecklenburg or in Wake County. It shouldn't. As a matter of jurisdiction, it shouldn't. And I think those parties could properly come into court and say that they're not bound because they weren't present in this lawsuit. At the same time, I think the plaintiffs would take the position that this is a statewide injunction and that it does bind them. And if it is binding statewide, that has to be the conclusion. And so I think therein lies the reason that the court's jurisdiction was limited in the way that we say it was, because you run into exactly that problem and that conundrum, which shouldn't have happened. We shouldn't have non-parties being bound.
I want to go back to where you started, which is what exactly is before us at this point. Our order specifically said that the court hereby allows the petition solely on the question of whether the trial court lacked subject matter jurisdiction to enter its order of 17 April 2023. And as I hear your introduction at least, there's nothing about that particular order that you contend the trial court went beyond what this court asked it to do. Instead, you believe that that gives you the ability to argue that at least 3 of the findings, and I do want to understand better how much of Leandro 4 you believe should be overruled, or if you think the entire opinion is null and void. But I also want to figure out how far back does that allow you to go. And in particular, this issue of subject matter jurisdiction was decided at multiple points, it seems to me, in this litigation, including with this court's decision in 2004, where we said, in our view, the nature of a declaratory judgment action and the mandate of Leandro combined to afford the trial court and the participating parties greater evidentiary leeway than in a conventional civil action. In declaratory actions involving issues of significant public interest, such as those addressing alleged violation of education rights under state constitution, courts have often broadened both standing and evidentiary parameters to the extent that plaintiffs are permitted to proceed so long as the interest sought to be protected by the complainant is arguably within the zone of interest to be protected by the constitutional guarantee in question. So it seems to me that in 2004, what we said was that standing and subject matter jurisdiction are to be determined by the nature of this declaratory judgment action, the nature of the rights at issue, and whether or not they're within the zone of interest sought to be protected. And where the state is saying to the plaintiffs, we can't solve your individual county problem because we have a constitutional mandate to provide equal educational opportunities to all students across the state, where the state takes the position, we can't give you a remedy just Hope County, we have to remedy the problem statewide. Are you suggesting that we also have to overturn what we said in 2004?
I think you have to adhere to what you said in 2004. To go a little bit further into the same passage, the court said, consequently, the court will examine 2 things. And this is at page 616. 1, whether the plaintiffs have made a clear showing that harm had been inflicted on Hope County students, the zone of interest in this declaratory judgment action. And 2, and I'm reading in 1 and 2, but and whether the trial court's imposed remedies serve as proper redress for the demonstrated harm. The court made clear that the zone of interest, when it said that it was adopting broadened standard and evidentiary parameters in the 2004 decision, Hope County 1, that the zone of interest extended to Hope County only.
I just don't read this opinion that way. It says the children of North Carolina are our state's most valuable renewable resource. If inordinate numbers of them are wrongfully being denied their constitutional right to the opportunity for a sound basic education, our state courts cannot risk further and continued damage because the perfect civil action has proved elusive.
But you have to frame that statement also within the question that the court was trying to address, which, as it said, is a threshold question. We address whether the evidence presented regarding the plight of Hope County students was whether the individual plaintiffs in that case could present Hope County-wide evidence to prove their claims, or whether they could only prove individual claims that they individually had been denied a sound basic education. The court was saying it was broadening the parameters out to Hope County to allow general evidence around Hope County to prove the individual plaintiff's claims. But it didn't go further. In fact, in the passage I just quoted, it very plainly made clear that the zone of interest was Hope County only. And again, the court also said that it's holding mandates related only to Hope County and then remanded for proceedings on the other claims. If the court thought it had extended the zone of interest out to the state as a whole, there would have been no need to do that, to send that remand.
Well, no, I believe that this court in 2004 appropriately recognized that further proceedings would be needed to determine statewide, and then we have the following years and years of evidentiary hearings, adversarial hearings where the state came in and said, no, we are providing a sound basic education. The plaintiffs came in and said, no, here's our evidence about how you're not providing a sound basic education. And so that brings me then, let me come to Leandro 4 and ask you if you are asking us to overturn our finding in that case, in that opinion. So this is from paragraph 180. The November 2021 order begins with thorough findings of fact regarding the long and extraordinary history of this case. These factual findings document the trial court's previous repeated findings of a statewide constitutional violation, the state's repeated failure to adequately remedy that violation, and the trial court's repeated deference to the executive and legislative branches to do so. The order's factual findings conclude by observing, in the 17 years since the Leandro II decision, a new generation of school children, especially those at risk and socioeconomically disadvantaged, were denied their constitutional right to a sound basic education. Further and continued damage is happening now, especially to at-risk children from impoverished backgrounds, and that cannot continue. Are you asking us to overturn that factual finding?
Yes, ma'am, because I believe it was erroneous and is not supported by the record.
And so why wouldn't that be appropriate on a petition for rehearing?
Your Honor, as far as the difference between a petition for rehearing and bringing up this order, I think the court has to recognize the very unique procedural posture that we were in when Hope County 3 was decided. As you recall, there were two appeals. There was an appeal, one from the writ of prohibition, which enjoined the transfer provisions of the November 2021 order, and there was a second appeal, the one that we participated in, I'll call it the -2 case that resulted in the decision. The court consolidated those two appeals sua sponte when it issued its decision in Hope County 3 for the purposes of deciding those issues in the opinion. It then said, we will stay the writ only until such time as additional issues are brought up. We moved to brief additional issues, one of which was standing, which was not addressed in Hope County 3. And then during that time, Judge Ammons ended his order recalculating it, and we appealed it as well and sought bypass.
But I understand you to be saying that it is your position that there is evidence that these factual conclusions about whether or not the education that students in this state are receiving is a sound basic education, that you have facts that show that this court was wrong. And what I don't understand is how you can come to court at this late date. Why didn't your clients intervene much earlier to present those facts to the court?
Those are two separate issues as to standing. Frankly, the court didn't have jurisdiction and the plaintiffs didn't have standing to secure a statewide judgment nor to secure a statewide remedy. Our standing argument doesn't depend on that finding. As to the next three arguments, our political question argument, our advisory opinion argument, and our friendly suit argument, those do require overturning Hope County 3's determination that there was a statewide judgment. But you suggested that Judge Lee's order from his transfer order from November 2021 incorporated years of findings. It did incorporate a number of orders that he had issued, all of which were the series of orders that led to the imposition of the CRP and his ultimate requirement of the transfer. But the very first of those all cite back to the concept that somewhere in the record in Judge Manning's proceedings, there was a statewide judgment after Hope County 1. The court in Hope County 3 looked only to 3 notices of hearing and a report from the court. Nothing was a properly entered judgment. Nothing was properly entered after a trial. Most of these orders were not entered as a result of adversarial proceedings, but instead in advance of adversarial proceedings. They noted preliminary questions from the court that it wanted to address and observations from ex parte review of statistics and testing, which this court said in Hope County 1 that standardized test scores alone are not enough to show whether students have been offered an opportunity for a sound basic education. So the record's entirely deficient between 2004 and the time Judge Lee took it over in 2016 to find any judgment. There's no judgment there. Judge Lee simply said, well, somewhere in there was a judgment. There have been years of factual findings, and based on that, switched the burden. Now, there was a remand for the court to look at the claims of the other counties. He flipped the burden. He denied the State Board of Education's motion under Rule 60 because the state had not shown compliance, as opposed to the plaintiffs had proved their case. He treated everything he was doing as a remedial phase. He assumed a violation. So Judge Lee did not enter a judgment finding a violation. He simply entered remedial orders based on the assumption that a violation had been found by the judge that preceded him.
Counsel, I wanted to go back to another point from Justice Earle's questions, which was, as I understand it, there were periods in this case earlier on where the understanding was that really the only relief the state itself could provide would have to be on a statewide level. So in other words, there was no way for the state, with the powers it had at the time, to say, okay, let's give some money to this particular school that needs help and then this school. And that the only option was to do it at a statewide level. But my question is, as I read Leandro 4, the need to correct this constitutional violation, so to protect the privilege of education that's in our state constitution, the Constitution itself empowers the court to override things like the appropriations clause and instruct that money be spent from the Treasury. If that exists, the power to sort of break down these rules that would otherwise exist, why couldn't a remedy be ordered on a district-by-district level or even down to the school-by-school level and say, this is how to fix this school, this is how to fix this school?
We believe that the court shouldn't have gotten to the question of the appropriations clause and exactly how far the judiciary's power goes there, because standing and the subject matter jurisdiction issues should have precluded it from getting there. So, I mean, first of all, I don't accept, and I don't think you would expect us to, that the court actually has a far-reaching power that would allow it to overcome the appropriations clause. I realize that, Hope County 3 holds that. I don't think it should have gotten there. But the other point to your question, though, is the court still had to follow some procedure. It had to, now, Leandro 1, the very first opinion says there has to be clear and convincing evidence of a violation before the court's remedial powers can be invoked. Hope County 1 says, okay, the zone of interest and the evidence that was before us in the only trial that was conducted was limited to Hope County. Other claims have to be proven before the court's remedial powers can be invoked. So the court doesn't have jurisdiction to start exercising remedial powers before a violation is found. And that's really the heart of our advisory opinion argument, which is that the court was issuing remedies for a claim that had never been alleged nor proved. It just simply went to answer what would need to be done to improve education. Back to the point I believe you started with, Your Honor, which was, excuse
I think my counsel,
Well,
sorry, my colleague had a question.
Yeah.
I want to make sure your question gets answered.
Okay. As to the state's representation that it can only solve this on a statewide basis, one, parties cannot confer jurisdiction on a court. Two, the plaintiff's assertion that the state said that comes from an April 2002 letter to Judge Manning prior to this court's decision in Hope County 1. So to the extent the court in Hope County 1 said standing only extends to the county where the individual plaintiff resides, because and that's not just simply always a rule, that's the rule based on these claims because they're county specific and district specific, then the fact that the state said, well, we want to solve this on a statewide basis really doesn't confer jurisdiction on the court to order remedies in other counties. Two, the fact that the state says, okay, we're going to solve Hope County's problems with a statewide initiative does not mean that the court has the power to order the state to implement those remedies anywhere other than where the violation is found.
So as I understand your answer to Justice Dietz' question, there is never going to be a situation where even if every single one of the 115 LEAs are represented by parents or children, there is never going to be a situation where this court can say, because there are failures to provide a sound basic education, there's never going to be a situation based on your theory of subject matter jurisdiction where we can tell the state you have to appropriate money to solve this problem. Even if the trial court finds that lack of funding is what is leading to these Leandro violations.
Well, first, that's a fundamental constitutional question that you shouldn't reach until you have standing and an appropriate case to get to it.
But I want to hear the hypothetical of where that happens.
But I think that the point of jurisdiction turns on the claims the plaintiffs asserted. Their claims are that the conditions in their individual districts are so bad they're being denied an opportunity for a sound basic education, and that the state should step in and essentially either override the district's poor performance or its poor administration of the resources it's been given. That claim is necessarily district specific. You could imagine a claim that could be statewide. You could imagine a claim that said, look, the state has issued a law that says we're not going to teach reading in 3rd, 4th, or 5th grade. Well, the court could say, look, that's so fundamental to a sound basic education, and at the time that it's being delivered, so fundamental to a sound basic education that it's constitutionally required. That would be a statewide policy that could turn on statewide questions. The plaintiff's claims don't turn on statewide questions, they turn on district-specific questions.
But isn't the statewide funding system what they were fundamentally challenging in the 1995 amended complaint? They say, under the state's education system, including its system for funding, the quality of the educational opportunities vary substantially according to where a child happens to live. The educational opportunities afforded to plaintiff school children are substantially inferior to those offered to children in wealthy school districts. This is a result of the state's system for funding education, which allocates substantially less money for the education of school children in plaintiff districts than it does for school children in wealthy districts. They are challenging the state policy of how schools are funded.
One of their claims originally was that the state's funding allocation system allowed for disparities in funding and unequal funding across districts. This court in Leandro 1 said that that was non-justiciable. It said, and it upheld dismissing that claim because it said the Constitution anticipates that there will be disparities in funding and differences in funding across districts.
But it did say in Leandro 1 that it was justiciable to determine whether or not every student is receiving a sound basic education. And I haven't heard you answer Justice Rick's question. Basically, are you saying that if there, and so I assume that what you're, maybe you need to tell us what you think would confer standing to, you suggested if you challenge a statewide policy, but that funding isn't apparently a statewide policy, but assume that there is standing to challenge the state educational system and whether or not it's adequately funded. I don't know that I've heard you say whether or not this court has any power to require a remedy, if that is viable.
Yeah, I think it has the power to impose remedies subject to the limits of separation of powers, which under the law as it existed prior to Hoke County 3 would have said that the court did not have the power to order money out of the Treasury or an appropriation.
So
Go ahead.
So I hear the answer then that if the remedy, no matter what the trial court finds as to what's causing the Leandro noncompliance, if the remedy includes legislature, you have to fund public education, this court is without authority in any situation to order that relief.
This court can order all sorts of relief, and it can order all sorts of on-the-ground relief. The court, at least as the law had been formed prior to Leandro 4, Hoke County 3, was that the court could not order an appropriation from the Treasury. I do want to address, though, this point that the funding claim remained. Judge Manning, in his four-part decision, took pains, and this is recounted in the Hoke County 1 decision at page 632, that in sum, the trial court found that the state's general curriculum, teacher certifying standards, funding allocation systems, and educational accountability standards met the requirements of Leandro, and that the bulk of the core of the state's educational delivery system is sound, valid, and meets the constitutional standards enumerated by Leandro. So not only...
I thought we weren't bound by that anymore.
By Hoke County 1?
No, the four-part judgment.
You were bound by the four-part judgment as, I mean, it's law of the case as modified by this court's decision. This court didn't buck, if you will. It didn't overturn Judge Manning's conclusion that the issue was not the funding allocation system or the curriculum or in the statewide educational delivery system, but instead was implementation at the district level. That's where he found the violation. The court said, look, the claims don't extend beyond Hoke County. It upheld this. It didn't touch this portion of the rule.
I'd like to go back to the scope of our review here. So in our order, we granted the PDR for the limited purpose of addressing subject matter jurisdiction with regard to the trial court's order of 17 April 2023. Is it your position, well, let me just ask you, put it this way, is there any way that you win on subject matter jurisdiction if we don't revisit Hope 3?
Yes, Your Honor, there is. And it relates to standing because, again, that was not addressed in Hope County 3, and it doesn't turn on whether or not there's a statewide violation. It turns on whether or not the court had jurisdiction because the plaintiffs had standing to obtain a statewide remedy.
So we could conceivably hold no subject matter jurisdiction as to the trial court's order without reaching the validity of
Yeah, yes, Your Honor, and there's been some question about why, if it's Judge Ammons' order, are we going back further to the orders, the predicate orders that ordered the injunction he was enforcing. His order expressly amended Judge Robinson's 26 April 2002 or 2022 order and Judge Lee's 10 November 2021 order, the transfer order that got us here. Judge Lee's order expressly incorporated by reference all of the preceding orders that he issued requiring the state to hire West Ed, develop the CRP, and imposing the CRP. All of those orders travel together and are predicated on each other and are incorporated into the order that's before you. Your Honors, I see that I have about 9 minutes remaining, and I'll reserve the rest of my time unless there are any immediate questions.
Thank you, counsel. We'll hear from the appellee.
Mr. Chief Justice, Associate Justices, may it please the court, I'm Melanie Dubas on behalf of the plaintiff appellees. With me here today is Larry Armstrong. He is the county attorney to the Hope County Board of Education. Also, my colleagues Scott Basil, Catherine Claudefelter, and Ashlyn Kloss are here with me today on behalf of the plaintiff appellees. In the last 30-plus minutes, Mr. Tilley addressed exactly one time the issue that is before the court, and that sole issue is, I quote, "The court hereby allows the petition solely on the question of whether the trial court lacks subject matter jurisdiction to enter its order of 17 April 2023. Regarding the other issues that Mr. Tilley did address during his argument, this court has already found, at best, they reveal a fundamental misunderstanding of the history and present reality of this litigation. At worst, they suggest a desire for further obfuscation and recalcitrance in lieu of remedying this decades-old constitutional violation. The defendant interveners now have moved beyond just obfuscation and recalcitrance, and they seek to drag the court into their gamesmanship. They invite this court to ignore the court's own rules, Rule 31. They invite this court to exceed the scope of its own order that I just read, and to ignore the rule of law on which our judicial system is founded. It has been the rule of this court for over 100 years that the court will not disturb its prior holding in the same case, even if it would have overturned that holding on a properly presented petition for rehearing. We do not have a properly presented petition for rehearing in this case. Nevertheless, that is what the defendant interveners are blatantly asking this court to do, to go back and rehear and overturn Leandro 4, which is binding precedent decided merely 14 months ago.
I'd like to ask you the question that I asked the other side near the beginning, which is, are any of the plaintiffs in this case still students?
That doesn't matter, Your Honor, because in Leandro 2, this court found that the plaintiff school boards are proper parties, and the plaintiff school boards do have standing to bring the claims. So whether there are or not students, there aren't, as far as I know, Your Honor, at this point. But it doesn't matter, because the plaintiff school boards are proper parties, and that's been the law of the case since 2004.
So the answer is there are no students left in the case.
There are no current Hope County students who have intervened as part of the case. However, the Hope County and the other plaintiff school boards who have standing are still pursuing the claims.
Well,
and the court has held that they are. And if the 400,000 students who do have evidence to show constitutional rights have to bring individual claims? Is that the court's suggestion, that the plaintiffs in Hoke and other counties have to bring individual claims? I think that goes to Justice Deet's point about when does the case end?
So going back to Hoke 1, what we actually said in Hoke 1 is that the school boards, quote, have no justiciable claims. We said that they could stay in the case because it was a declaratory judgment action and that they'd be affected by the outcome. But we made it crystal clear in Hoke that the right to the opportunity for a sound basic education is one that students possess, and so, and not school boards. And so if there are no plaintiffs left in the case, doesn't that mean we have no party left in, or if there are no students left in the case, doesn't that mean we have no parties left in the case that are entitled to relief?
Absolutely not, Your Honor.
Okay,
Absolutely not.
Can you explain to me why that is?
Because as Your Honor just said, and as Justice Earls quoted the language of this court from Leandro 2, in this declaratory judgment case, and particularly in a case of paramount importance of education, which is part of our constitutional Bill of Rights, that the court has to look beyond and broaden the issues of jurisdiction and standing, and that is exactly what this court did. The plaintiff school boards are affected by the rulings of this court and the trial court. They have standing. So absolutely, there are parties involved in this case that have standing under
One thing
this
that's
court's own
awkward
ruling.
about that is that, you know, I'm thinking about the students. I want to do what all the parties are saying in their briefing, which is this case needs to get to the outcome, which is to cure a very serious violation of the constitutional rights of students in our state. But one thing that's awkward is your client is the government. And it's not just the government, but it's the very government that's violating the children's constitutional rights. Can you not see, just put on your hat of objectivity and think about the perspective of someone watching this case and saying, is that fair that this is the very school district that's violating the children's rights now standing up in court and insisting that they can say what the right remedy needs to be without giving the students their day in court? And that, I heard that to be, I think, what Justice Allen was getting at is don't we need to make sure that the people who are going to get the remedy at least have the opportunity to say, I understand this is happening and this is what I think needs to be done to help me get a sound basic education?
I think it's very simple, Justice Deetz. And again, I think it goes back to the court's holding in Leandro 2 and Judge Manning's finding that was affirmed by this court of who is responsible, who has the constitutional duty to provide the children the opportunity for a sound basic education. And Your Honor, it is not my clients. It is not the school boards. It is the state of North Carolina that sits on both sides.
Well, let me ask you about that, Counselor. Yesterday, we heard arguments in the case dealing with red light cameras, right? And the state has provided local education units and local municipalities with the ability to generate revenue for students. Does the failure of Hoke County to take advantage of that process come into play at all?
No, absolutely not after Leandro 2, Your Honor. The court very clearly stated that the state cannot abdicate its constitutional responsibility by blaming the local education authorities. That is very clear.
So your failure to exhaust other procedures to generate revenue plays no role in this consideration?
No, absolutely not. Absolutely not.
Put another way, what is the interrelationship between localities' decisions to use schemes to police for profit? How does that relate to what the state's obligation is to provide a uniform system for sound basic education statewide?
And again, Justice Riggs, I do believe that this was discussed thoroughly in Leandro 2. The intersection is that if the local education authorities are failing for whatever reason, for lack of funding, for lack of local funding, lack of ability to raise local funding, lack of taking opportunity to raise funding, or if it's the administration of the local educational system, whatever the reason is, the ultimate responsibility for solving that issue and providing those children the opportunity lies with the state.
But I guess, can you help?
Go ahead.
Can you help me understand then? Like, let's suppose a school district just said, you know what, teaching reading and writing is really hard. We're just not going to teach reading and writing anymore. We'll maybe do some history or math, but no more reading and writing. And that would be a clear case of students could bring a constitutional challenge and say, we're not going to get a sound basic education if you don't teach us to read. Am I understanding your position to say you would not sue the school board? You would sue the state and say, state, come enforce something against the school board? That seems odd because you're an arm of the state, are you not?
Well, again, Your Honor, this court has already addressed this
Well, who was
in a
the
case about
party
5
in-
years
in
ago
Dim-
in Halifax County.
In the Dominski case, who were the parties in the on the other side of the V in that case?
Your Honor, I'm not familiar enough with the Dominski case to answer that question, but in the education
we've had
case
ca-
about Halifax County, when the plaintiff did bring claims against the Halifax County School Board and the state, this court held those claims, dismissed those claims against the school board because the Leandro obligation is the obligation of the
I understand.
state.
What I'm trying to make sure we do in this case, because we need to provide relief for these students, is not have a situation where students could say, what happened? I didn't get my day in court. And I understand because you've been fighting this fight and I know you're doing it in good faith. I'm just concerned that there are students that are out there who may say, wait a minute, that's not fair that the government is the one that's deciding this for me. I never got to come to court and say, here's how you fix my school. And can you see how that might trouble people if, and maybe this gets to the question which I wanted to ask at some point, what will happen? Answer my question I asked to your friend, what happens if there's more Leandro suits now? Where do those go?
Well, let me start to try to answer your question, Justice Deeds, by talking about the public system of education in North Carolina. I believe the defendant intervener's arguments actually reveals a fundamental misunderstanding of the system and how it works. And in the Guilford County School Board case that they cite in their briefs, there's a really good explanation of the public education system. And it says the legislature is required to promote popular education by devising and establishing a plan, a scheme consisting of necessary and well-appointed constituent parts, and the whole organized into a complete system of public schools. Such system must be general, not local, not limited to one or more places or localities in the state. So for example, let's take teachers. I think we all agree in Leandro 2, this court affirmed Judge Manning's rulings that a Leandro-compliant resource allocation system is one that provides a well-trained certified teacher in every classroom. As we sit here today, in the 2013 report that DPI provided to the legislature as part of the public record, and it's cited in the state's brief, according to that evidence, that report, today there are 114 classrooms in Hope County that are not staffed with a well-trained certified teacher. Violation, prima facie, right? By comparison, in Speaker Moore's home county of Cleveland County, there are 115 classrooms that are not staffed by certified teachers. So under their argument, Hope County gets the 114 teachers, either provided by DPI or whatever, and Cleveland County does not, because it's not a plaintiff. And what would a Hope County only remedy look like? So we have schools of public education across the state in our university system. Does the state dictate that the first 114 graduates have to teach in Hope County? Do you provide scholarships across the state to high school students, but they only get the scholarships if they commit to teach in Hope County? They can't go to Cleveland County or any of the other 114 counties who similarly have a proven violation with no teacher. It is a system, Your Honor, that works on a statewide basis.
So my students and parents up in the mountains in some school district that never heard of Leandro, so they, 2 years from now, what happens to their lawsuit when they file it, in your view?
So if there is a student, and Your Honor, this goes to another point about the adversity in this case. The comprehensive remedial plan is not perfect. It is not the plan that plaintiffs would have put before the court. There are pieces in the West Ed report that are not included in the comprehensive remedial plan. So yeah, it's possible that there is a student in Avery County, a student with disabilities, for example, who may have an individual Leandro claim, who may have a need that is not met by the CRP. What would happen? That student would bring his claim. He's not bound. I think we all would agree to that. He would,
But let me change the hypo some, because
Sure.
yes, that's the Dominski scenario, and I agree, that remains the ability to come in individually. So if you're being so bullied at school, for example, that you can't even learn, you might have a claim that we could call a Leandro claim, but it's really a privileged education claim. But my question is, what if it's a huge group of students, and it includes some are at risk, some have disabilities, it's just the parents get together in the school and say, our kids are not getting a sound basic education. And let's say they hire this consultant company called East Ed, and East Ed comes in with some ideas that are different than West Ed. Is your position that their rights are being decided in this case, they can't bring that lawsuit, or can they? I'm just trying to get an answer to that question.
I believe they can bring that lawsuit, Your Honor. I believe they bring that lawsuit. I believe they bring it against the state of North Carolina. Perhaps they also include the State Board of Education. If they prove that that the violations are not being redressed by the comprehensive remedial plan, then there may be an order that the comprehensive remedial plan needs to be amended. As I said, it's not perfect.
But Leandro 4 says that the comprehensive plan is comprehensive. It's pretty clear about the fact that this is it. So if the comprehensive plan isn't actually fixing all these problems, don't we need to make sure that's happening now and have some mechanism to do that, to give notice to students and say, we need to do this, we need to do it right now so we can cure this constitutional violation, and find some procedural way to do it all at once so we don't have to risk that happening later.
I think what Leandro 4 says is that the comprehensive remedial plan is the only plan that was ever put before the court. I mean, it's called a comprehensive remedial plan. It is the only plan. It is the state's plan. Again, plaintiff's position is, it's not perfect. If the legislature believed that there was a different plan or a better plan or multiple plans, they did have the opportunity to come in and present those, and they never did.
I'm not concerned about the legislature. I'm concerned about students. So people who, it's their rights being violated, and they're going to be told, we don't get our day in court. And I'm just trying to make sure that can't happen. But if your way to get around that problem is to say, well, it won't happen because we can have as many Leandro lawsuits as people want to bring, it seems like we're not achieving what Leandro 4 instructed that we need to achieve here, which is to get to one comprehensive solution.
And Your Honor, we are certainly not achieving what Leandro 4 wanted to achieve under the defendant intervener's proposition. Again, that guarantees at least 114 more lawsuits. Again, when Hope County gets its 114 teachers, I would expect that the other counties who have classrooms that are not staffed by certified teachers will file their lawsuits. And how do we deal with that? Whoever gets to the courthouse first gets their remedy. And if you're the last one to file, then you wait in line for 2, 4, 5, 8 years with classrooms that don't have certified teachers. It's completely impractical, Your Honor.
Well, don't we have a 30-year head start here on getting all this ready? So if we felt like we needed to use some of the procedural tools that exist in the law, like a class action, like creating a state version of multi-district litigation, something to make sure we can get to the level of the students themselves and say, we're going to do this for you. We will give you notice, though, and the opportunity to come in and say what you think needs to be fixed in your school. We could order that to be done very quickly. So, because I agree we need to fix this constitutional violation, but so if we're putting aside the rhetoric about we can't have any more delay, what would be wrong with doing that? Just having a process, finding a way to let students know, we're going to tell you, we're going to resolve this right for you, and we'll give you an opportunity to be heard if you want it before we do that.
I don't think there would necessarily be anything wrong with that, Your Honor. The problem is there is absolutely no procedural mechanism in this case, no proper mechanism in this case to do that. Again, the legislative interveners could have brought that up.
We've done other rules before, like, for example, your friend did point out that it's long been the case that the appropriations clause means only the legislature with an appropriation can order money be paid from the Treasury, but we know now that what's at issue in this case, the privilege of education, is so important that we can override some of those other principles about the structure of our government. So why couldn't we do the same thing with procedural rules about a lawsuit, create a multi-district litigation process, or create a streamlined class action system?
Because Leandro 4 is not properly before this court, Your Honor. This court has decided that case. Never in the history of this court has it ever gone back to overrule or change a case where there has not been a petition for rehearing. The defendant interveners didn't do that. The controller did not do that. The controller had every opportunity to present arguments and did not do that. That is not procedurally proper. That is what the defendants are asking the court to violate its own rules.
Counsel, let me ask you, in High versus Pierce, in 1941, this court said, where there is no jurisdiction of the subject matter, the whole proceeding is void ab initio and may be treated as a nullity anywhere at any time for any purpose. Is that still good law?
Your Honor, it is true that subject matter jurisdiction can be raised at any time, but the subject matter jurisdiction before this court is the jurisdiction over the April 17 order. This court has already addressed subject matter jurisdiction.
Understand,
and
counsel.
what they're arguing is not that this court doesn't have jurisdiction. They're arguing that the trial court gave you the wrong remedy, and that's already been decided.
Counsel, I understand. Is High versus Pierce still good law?
I don't know the answer to that, Your Honor. We have cited multiple cases in our brief, as have the other plaintiff parties. Again, that this court does not, without a proper petition, go back and revisit, and subject matter jurisdiction has already been decided. Before I cede the remainder of my time to Mr. Park,
Actually,
do wanna
I have
leave
another question. So if we conclude, you've told us there are no students left in the case. Under Hope 1, that means there's nobody with any justiciable claim left in the case. If that's what we conclude, what should we do?
Your Honor, let me leave you with this. Judge Manning always said that this case is about the children, and you've asked about the children. There are 69% of the state's 3rd through 8th graders cannot read at a level that the state standardized test says is Leandro compliant. That is 480,049 children. And those are 480,049 3rd through 8th graders. It doesn't include the high schoolers. 449 children who will become the 3rd generation of children since this lawsuit was filed to pass through our state school system without the benefit of relief. If this court takes away from them the relief that it finally delivered 14 months ago in its Leandro 4 decision. I'll cede the rest of my time to Mr. Park.
Mr. Chief Justice, Associate Justices, and may it please the Court, I'm Ryan Park from the North Carolina Department of Justice on behalf of the state. The unanimous and bipartisan rulings by this court in Leandro and Hope County are shining lights in this court's jurisprudence, ranking among Bayard and Coram as foundational pillars of our state's constitutional fabric. These decisions for the first time breathed life into Section 15 of the Declaration of Rights, which requires the state and imposes the duty on the state to guard and maintain the people's right to the privilege of education. The basic question before this court and in the prior appeal is whether that duty is judicially enforceable. Nothing that should be relevant to this court's decision-making has changed in the intervening 15 months. Most of the arguments you've heard today from my friend Mr. Tilley, he concedes, are the exact same ones that he made 2 years ago and a majority of this court rejected.
Counsel, I want to make sure, because your co-counsel was unsure. Is High versus Pierce still good law?
Yes, Your Honor, I believe it is. And I think the other principle that applies on the issue of subject matter jurisdiction and when it can be considered is the law of the case. So there are 3 cases that I believe plaintiff cites in their brief where this court has said that even jurisdictional rulings have to be final and are encompassed within the law of the case. And yes, Your Honor.
I understood your friend for Hope County to say that Leandro lawsuits can only be brought against the state. as a state, do you agree with that, or can there be Leandro suits against school boards, local school districts, that sort of thing?
Well, I believe that school boards could be proper defendants in a Leandro lawsuit. And the way that I think about the colloquy that you have been having on this issue is that this lawsuit is, in all intents and purposes, a facial challenge to the state's funding structure, which the court rejected in Leandro 1, but also to the state as a whole, whether it's complying with its duty to guard and maintain the people's right to education. And there could be continued as-applied litigation in any individual context brought by individual plaintiffs or against school boards. Individual school boards could continue to bring lawsuits under Section 15. And the reason why they could is because Section 15 is an ongoing duty on the state. And this is, really kind of my main point, is that a lot of the ways that we as a state have tried to resolve this lawsuit, to bring a global resolution to plaintiffs' claims, are the same mechanisms we apply in complex civil litigation generally. And so a good example is our litigation against the manufacturers and distributors of opioids for fueling the opioid crisis. And what we've done there, this is over $56 billion, almost twice our state's annual budget in settlements. And the way we effectuated that settlement in North Carolina was through consent judgments entered by Wake County Superior Court judges against various defendants. And 85% of that money went to counties directly. Counties were not plaintiffs in that litigation. And the reason why a sophisticated defendant like McKesson or McKinsey would agree to that arrangement isn't because they're colluding with the state. It's because they understand that it's in their long-term best interest to try to mitigate the risk of this kind of complex litigation and resolve to settle it through a negotiated resolution that's entered by a court. But if these defendants, once again, start fueling the opioid crisis prospectively, of course, the state or individual plaintiffs could bring additional claims that relate to ongoing violations of law.
I think what concerns me, though, because I agree with you about that, and what I'm trying to figure out is how, because it could create an incentive, if what we're going to have in the future is just constant Leandro litigation, ongoing, sort of ad infinitum, that we need to find some way to ensure that there's not an incentive to just bring up part of the claim and not solve the problem and leave open the fact this doesn't work, we'll go back and get more. The goal should be comprehensive solution that cures the constitutional violation. And what I hear you saying is, well, let's just get some relief out the door and leave it open. And my question is that because you think it isn't possible to fully remedy the violation? Why not multi-district litigation? Why not a class action and just get their day in court now and do it?
So, Your Honor, I agree that there are aspects of this that could have been resolved more effectively if we had a class action or a mass action with all the counties as plaintiffs, or certified class of all parents in the state. That would lead to true global peace here. But what we have here is a resolution of what I think of as a facial challenge, where they're challenging the funding structure and the overall resources that are devoted to public schools in the state. And what it does is it would make any as-applied litigation much more difficult to prevail on. As Ms. Dubas has mentioned, I don't think anyone would disagree that at least there are areas of the state where we are failing the school's children. We're barely half of our students are passing the basic proficiency standards for reading and math that have been established by the State Board of Education. And that number has been steadily decreasing over the last couple of decades. And actually now it matches on a statewide level about what the figures were in Hope County alone in 2004. And so what we tried to do by entering into this global resolution, which, yes, does not foreclose all possible claims, is to raise up the overall educational system and bring some measure of peace, at least on a facial basis.
Counsel, I want to follow up with Justice Dietz's question. I don't know that we've gotten an answer from your side on this yet, but if a local education unit were to say, we're no longer teaching reading, what recourse would a family, a student, a community have in that situation?
I think that an as-applied challenge to that policy would be perfectly appropriate, and I would hope that this court were to order relief in that circumstance.
And once we step into that sphere, are we not becoming many legislators in that respect. We will no longer allow you to teach DEI because it's not related to reading, writing, and math. I mean, are those the types of decisions that we are called on to make now?
No, Your Honor. I think what the Constitution requires is that there at least be a minimum baseline of educational quality in this state. And this is not, as the court said in the 2022 decision, that this is not a policy choice. There are minimum standards that are constitutionally enshrined. It's in the text of the Declaration of Rights. And so I think a court could properly adjudicate that a school board or the state as a whole said we're not going to teach reading anymore. Well, that would be a facial violation of that constitutional right.
But couldn't someone come to us and say DEI is not a part of a sound basic education? Court, we need you to step in?
I think that claim would be cognizable. I think it would fail on the merits. But yes, I think that additional as-applied claims could be brought. And this actually relates to what I understand is the only issue before the court that the parties, that Mr. Tilley doesn't agree was decided in Leandro 4. So this is the question of standing, right? And the main issue there is that in all those scenarios that you just outlined, an individual plaintiff could challenge a statewide policy and as their relief say, I want the statewide policy to be changed. You don't actually need, as a matter of standing law, to have every single plaintiff joined in a class action, every single student joined in a class action to give relief. You wouldn't give relief by saying, okay, well, you can teach reading to the person who sued, but not generally.
Right, but, and this gets to, I think, a question that Justice Allen was asking. Suppose that the party that's bringing this, the plaintiff, is also the government. And suppose there could be a scenario where the remedy involves not only the state, so here it's Hope County School District and the state, not only the state having to do some things, but the remedy, let's say the consultants, sort of the West Ed type folks come in and say, we know you don't think there's anything you can do, school district, but actually we think there is. You need to make these changes. One of the things that standing ensures is that you can see how in that scenario, for the school district, they want to focus on what the state needs to do, and they don't want to focus on what they've done to violate their own students' constitutional rights. And part of what standing does is ensure there's someone in the case that says, hey, I don't have that conflict. I will make every argument that needs to be made for what's going to give our students a sound basic education. And it just seems odd to me that we have this scenario where the government is saying we have standing to sue the government and get a relief for children when the children aren't being given a voice, they're not getting their day in court. So what about that standing problem? What do you think?
So 2 points, if I may, on that question. I do believe that argument would be foreclosed by Hook 1. We made that argument. A state attorney 20 years ago made that argument to this court, and I think a good faith reading of Hook 1 rejected it and said that Hope County can serve as a proper plaintiff suing the state in this circumstance.
I'm really sorry to interrupt you, but I actually get confused in things. When you say Hoke 1, other people also call that a Leandro too, right? Yeah. The 2004 decision.
The 2004 decision.
Yes.
Yes, Your Honor.
So you read that, because I got to be honest, I read that the opposite way. I took the combination of the zone of interest and the discussion of why they were allowing the school boards to stay in as emphasizing that the students were the ones that actually would have standing to seek the affirmative claim. You disagree with that?
I do, Your Honor, and I think this has been the good faith reading that the state has had of this decision since Hoke 1 was decided. And as you know, we had about 15 years of proceedings where no one doubts that we were contesting in an adversarial situation the plaintiff's claims. So we've always read Hoke 1 as saying individual students don't need to be plaintiffs, and that at least in this declaratory judgment posture, the plaintiff school boards are proper plaintiffs. But if that is the true concern that the court has, whether there are proper parties, the scope of the relief, whether there, even going back to the broader issues, whether there has been a statewide finding of violation, there are solutions to this problem, to those problems, and we would welcome this court's guidance and the General Assembly's continued participation in these proceedings to try to resolve those kinds of particular concerns.
So just to be clear, your position is that Hoke 1 or Leandro 2, whichever way you want to label it, that gives school districts standing essentially to assert Leandro claims on behalf of their students.
Yes, Your Honor.
Now, how do you then deal with the fact that we expressly said in Hope 1 that school districts do not have justiciable claims? that they're only allowed to be involved in the case because they'll be affected by the judgment.
So I do not read Hook 1 that way, and I'll just represent in good faith that the state, for the last 20 years, has never read Hook
Well,
that way.
let me read it to you.
All right, yes.
We said, quote, they being the school districts, have no justiciable claims based on its infringement. That's the infringement of the right to the opportunity for a sound basic education.
So on page 378, this is what the state for 20 years has understood to allow plaintiffs, school boards to serve as plaintiffs in this litigation. It discusses the expanded standing and evidentiary parameters in declaratory judgment actions. And it says, while the precise party designations, i.e. plaintiffs of school boards, may not have been readily discernible at the time of the trial, the nature of the plaintiff's claims was such that they sought a declaration of rights, status, and legal relations of and among the parties. And so we've always understood, and Judge Manning and then now Judge Lee has always understood, that we did not need to add individual students as plaintiffs. And I think if we did, I think plaintiffs, at least plaintiffs' counsel, would have quickly remedied that concern. And again, if that is a true concern, we can move forward with that as the rule of law and on remand, and I'm sure that plaintiffs' counsel can cure that defect. I think.
Yeah, and I'm struggling with sort of a broader point because I realize you could you could find some students in Hope County that are willing to be plaintiffs, substitute them in. I'm still concerned about what we do with students in other parts of the state that have an idea of how Leandro can fix the constitutional violation they're suffering and just aren't getting a voice in this case. But I think I'm hearing you say, imagine we said, we will move this case along if you find the sort of solutions that you've described, some of which I think were in the opioid settlements. There's been many multi-district litigation cases that I know you're aware of in federal court that have found ways to, so we would not lose 30 years of work in this case. What is the state's position on if we did that so at least students get noticed that this is your time to say how to fix your school. We want your voice to be heard when we craft this comprehensive remedy.
So, Your Honor, 2 points on that, Your Honor. So, again, my understanding, how I perceive this case is it's a facial challenge to the statewide provision of education to all students, and that there's nothing as a matter of formal principles of collateral estoppel that would bar additional lawsuits brought by people who are not parties to this claim. And so I don't think anyone believes that additional as-applied litigation brought by students bringing those kinds of claims would be foreclosed by the comprehensive remedial plan. What I will say is, this is perhaps one of the highest profile lawsuits, issues of constitutional litigation in our state, and no additional county boards of education, no additional plaintiffs groups have sought to intervene or even file an amicus brief saying, well, we object to parts of this plan, it doesn't go far enough. And that is something that routinely happens in this situation. It has happened in the opioid litigation where the plaintiffs and the defendants, the Purdue Pharma and the victims of Purdue Pharma go on appeal and both try to defend the negotiated resolution, and outside parties come in and say, it didn't go far enough, we want more relief. So that is a routine thing that does happen, and it has not happened here. So I don't think the solution to the problem that you've identified is to say, well, we're not going to give what I perceive as facial relief because there might be additional problems that need to be identified in future as-applied litigation. And I think, Justice Allen, on the main question of standing, which again is the only issue that my friend Mr. Tilley doesn't dispute, was resolved already 2 years ago. I think that your decision in CSI resolves this question, that in CSI, there was the argument that the defendants made that, well, the scope of the relief went too far, and that is a question of standing. In that case, it was whether all persons convicted of felonies could register and vote after their term of active confinement. And the trial court said, yes, we give that broad relief. And what the court said in CSI is that might be a problem with the substantive merits of the claim, but is not a problem that sounds in standing. And of course, the court held that, yes, there is standing, but the claim failed on the merits. So I think this issue of whether a problem that might be perceived as to the scope of relief is simply not a question of standing. And my friend has not been able to identify any court in the history of the state that has ever said that an overbroad relief means that there's no standing. And that is, obviously what we're here to discuss today. So I'm happy to answer any other questions, but I guess I will close with this, that I believe in this court, and I believe in its authority to remedy constitutional violations that have been identified by this court and other courts. I don't think that anyone in this courtroom really believes that courts lack the power categorically to remedy constitutional violations when that remedy might require the appropriation of funds. We are routinely subject to court orders that us in the executive branch or in the legislative branch might believe are wrongly decided, and to comply with those orders, we have to expend funds. One example is the MAP Act litigation, where we involved one parcel of property, the Chapel case, but it prompted us, in good faith, to resolve hundreds and hundreds of cases amounting to over $1 billion in settlements, because we understood that we had a good faith obligation to comply with the court's order and try to vindicate the constitutional rights, respect the constitutional rights of our counterparties. And that is what has occurred here. I think that if the court does believe that it lacks the authority to issue orders where compliance might require the expenditure of public monies, then it really is quite dangerous for our legal system, that the state could, whatever disfavored right in the Declaration of Rights might arise in that particular context, the state could say, well, we're not going to pay just compensation for taking a private property. We're not going to refund an unconstitutional tax. And I don't think anyone wants to live in that system. So we welcome the General Assembly's continued participation in this lawsuit. We welcome this court's guidance on how we can proceed here to vindicate the constitutional rights of the people's children. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. First, to answer my colleague's statement that there's no case in North Carolina that ties the issue of the remedy to the issue of standing, I point this court to the case that he said was a shining light, Hope County 1. Hope County 1, as I said before, found that the zone of interest affected by the plaintiff's claims was the conditions in Hope County and the students in Hope County, and then at page 616 said that consequently its examination would extend to whether there was a clear showing of harm in Hope County, which it said the zone of interest in this declaratory judgment action, and then 2, whether the trial court's imposed remedies serve as proper redress for such demonstrated harm. The court was focused on whether the remedy was necessary, which is something that quorum requires, which is something that Alamance County requires, that the remedy be no broader than necessary, to the issue of standing, to how far the plaintiffs could represent. Because frankly, if the plaintiffs have a claim that is based on the conditions in their home district, they can't represent, because they have no knowledge of and are not representative of those students in Asheville City Schools, or those students in Chapel Hill Carrboro schools. There might be statewide claims that they could assert, but they didn't here. Mr. Park repeatedly asserted that he views this as a facial challenge, and he cited the plaintiff's original claim that the funding allocation system in the state was unconstitutional and because it resulted in disparities. He admitted, though, that Leandro 1 rejected that claim. With that rejection, this case turned not from a facial challenge about statewide policies, but to an as-applied claim. And I'll cite Hope County 1 on this point. The court said that with Leandro, the thrust of the litigation turned from a funding issue to one requiring analysis of the qualitative educational services provided to the respective plaintiffs and the plaintiff interveners, meaning an examination of the conditions in the individual districts. The case is really essentially as applied. Justice Dietz, I would address also your questions about what procedure would allow for the participation of someone who disagrees with the comprehensive remedial plan. And I'd first point out that there are many policy decisions in the comprehensive remedial plan that one could disagree with. The comprehensive remedial plan requires the revision of the state's accountability standards for and the balance of proficiency versus growth in grading student performance. It moves to a pay-for-performance model for teachers. It focuses on providing scholarships through the UNC system in order to get certified teachers into classrooms where legislative measures have typically said, okay, here's direct money to pay a stipend or a signing bonus today to get a teacher in the classroom now. You could make any of those choices. You could certainly say that a plaintiff would say, look, give me money to go somewhere else, or allow me to at least pick a non-failing school within the district. Give me school choice, and that may be a remedy. If the state is bound to the comprehensive remedial plan, those individual cases are going to come either with conflicting judgments, if they're vindicated, or run directly up against the comprehensive remedial plan in that they can't order the relief because it's contrary to what the CRP
Yeah, I did want to ask.
provides.
Go ahead.
Well, just to follow up on what you're arguing now, as with any litigation, if the state had a different plan or wanted to raise those concerns about the consent judgment that was proposed, why wasn't it incumbent on the state or any other student or any other person who shared the concerns you just raised? Why wasn't it incumbent on them to either seek to intervene or to present those concerns to the trial court?
With due respect, Your Honor, we tried to intervene. We tried to intervene in 2011, and Judge Manning refused because he said he had the state before him and only wanted to listen to the Attorney General.
Right, but
we weren't allowed to intervene.
But the comprehensive plan was not in 2011. And we're talking now about this consent decree and seeking to determine whether or not it can be enforced. And your clients were parties in 2021.
We were parties in 2021. We weren't parties at the time the comprehensive remedial plan was imposed.
And
We
nothing
intervened
stopped-
at the point at
nothing
which we
stopped
felt we
you.
could intervene as a matter of right because there was a challenge of an act of the General Assembly, the budget. And that gives us a different right to intervene as a matter of right. We'd already been denied discretionary intervention.
But there was nothing stopping you when this comprehensive plan was under consideration from seeking to intervene at that point.
Your Honor, we had been denied permissive intervention, and the grounds wouldn't be different until we had a conflict with the statute, and that's when we felt we were.
But if you're objecting to the comprehensive plan and you had critiques and suggestions denied before, you would have grounds then to say, court, the legislative interveners, my client at this point, have a concrete proposal to fix Leandro noncompliance, not just picking at problems with the comprehensive plan, but move us forward so that we can get compliance with Leandro.
And to that point, we intervened within 6 months of the time the comprehensive remedial plan was actually ordered. It was ordered to be implemented in June 2021. We intervened in December 2021. So we intervened within 6 months of its implementation.
And I guess the question, or the point I was going to get into, the question I have for you is that, again, it's no offense to you and your clients, but I'm not particularly interested in legislators. I'm interested in the school children. And the idea that school children and their parents would need to somehow review the dockets of in courthouses all over the state to know if there's a case called Leandro and then know to show up and intervene seems to me to be way outside sort of the foundational principles of what you would have to do to not be bound by a decision. And that is what I wanted to ask you about, is the idea that this is a facial challenge. So one of the things I'm struggling with that is typically when you bring facial challenges, there's no way for the individual people who are benefiting, so, because the idea is it applies on its face, that's where the term comes from, that they could disagree about the remedy, because typically with a facial challenge, the remedy applies equally to everyone, and it's usually some sort of injunctive or declaratory relief. So it's odd here, because this is granular. You could have people say, I don't agree with this particular part of the relief, and I don't agree with this one in my school district, and that's why it seems like it doesn't fit naturally into what we think of as sort of typical facial challenges.
Your Honor, I think that's right. There's a due process component to the limits of standing, right? And two, there's also an issue about where people expect these policy decisions to be made. If you recognize that these are policy decisions about which everyone can disagree and come up with different alternatives, and that you have to decide between those competing alternatives, and you want to give everyone in the state a voice, and you want to create a procedure to do that, you've created what is essentially across the street in the legislature.
But that's your political question argument, which has been rejected at least twice in this case.
It's been rejected once. There's a difference between determining whether education falls below the standards of Leandro and how to go about solving it. Our argument is that doing that mix, the mix of all the levers, how hard to pull on each one, which alternatives to pick, those are policy questions. And there are numerous cases in Leandro and Hook 1 where the court did find that certain decisions are policy-making decisions, such as the age of compulsory education. It also rejected the court's attempt to try to require pre-K because there was no universal pre-K because for at-risk students because there was no evidence that it was the only solution. Your Honor, Ms. Dubas also said, to end, I guess, but Ms. Dubas also said that there's no case in which this court has ever reversed an opinion unless it was on rehearing. That's simply wrong. This court has recognized time and time and again that stare decisis, while stubborn, is not dogma, and that if a decision is wrongly decided, if it conflicts with the Constitution, if it conflicts with prior precedent, which I submit to you that Hope County 3 conflicts with Leandro 1 and Hope County 1, then it should be overturned and corrected at the next possible moment. This is the next possible. Thank you.
Thank you, counsel. Thank you, Mr. Clark.